Good evening. My name is Elizabeth Anderson, and I'm the Executive Director of the American Society of International Law. I think known to most of you, and it's really a privilege to have you here to help us celebrate the nomination of one of our own here at ASIL to the ICJ. I have received many words of congratulations and cheers for Joan that I can't convey them all, but there are two that I thought I would share with all of you. The first is from the president of the society, who couldn't be here, David Caron, and he writes, "It is a great privilege for the American Society of International Law to host this evening's reception for the United States nominee for election to the International Court of Justice, Ms. Joan E. Donahue. I very much regret that I cannot join you this evening. Joan is a dear friend. Joan and I share a teacher, Professor Stephen Riesenfeld, and the three of us, Steve, now gone, share a deep commitment to international law and to the society. All three of us stood in this room many times. I know that Steve Riesenfeld would have been proud to see Joan's nomination and would, like I, have great confidence in the judge that Joan will be. Likewise, the society is proud that another of its members takes up the important work of the court. Joan has been a panelist on society programs and a member of its executive council. Joan, as you take up residence in The Hague, we hope that you always bear in mind that Tiller House will continue as a home for you here, and that the society's members around the world will always be ready to welcome you. The society is proud of the role played by all of its members in addressing the most challenging problems of the day on the basis of law and reason. This work is the heart of the Society's mission, and the Society holds a special place for its members who serve as judges in the international community. Stephen Schwabel, Thomas Bergenthal, Theodore Marone, to name only a few. Joan, on behalf of all of the Society, I wish to convey our heartfelt congratulations to you on your nomination and our very best wishes in the years ahead." From David. And chiming in, I also have word from our immediate past president, Lucy Reed. And she asked me to also extend her congratulations and strong support to Joan. Joan, as she writes, is a greatly valued ASIL member and former L colleague of hers. Lucy wanted Joan and others here to know that only a family commitment, a visit to her son in Rome en route to a long-standing business meeting in Milan, has kept her away from this important gathering. So she joins David in thanking you all for coming and for supporting Joan en route to the ICJ. So with those very heartfelt congratulations, I want now to invite two of the four members of the U.S. National Group to say a few words about Joan, and then we'll hear from Joan herself. We'll begin with John Bellinger, who, as many of you know, is a partner at Arnold & Porter, an ASIL counselor, and former legal advisor. And he'll be followed by Harold Coe, former Yale Law School dean and my professor, and currently the legal advisor at the State Department. And Harold will have the privilege of introducing Joan. John.
Great. Thanks, Betsy. And this is a great day for us to be talking about Joan's nomination to the ICJ. I see many of her friends here from different walks of life, from Covington, from GW, from the State Department, her two sons sitting here in the front row, who I have heard much about during the time I was legal advisor, but I've not met in person. So thank you all for coming out. I'm going to say just a couple of words about the process by which Joan was nominated by the National Group, and then a few words about why I personally, as a former legal advisor, think that this is a great nomination. This being the American Society of International Law, I think most of you all know that ICJ judges are elected by the Security Council and by the General Assembly based on a nomination of the national group of countries, not by governments directly, but by their national groups. So says the ICJ statute. The four members of the U.S. national group are members of the Permanent Court of Arbitration, and that is Harold Coe, the legal advisor, as chair, myself as previous legal advisor, David Andrews, who many of you know, who was the legal advisor during the Clinton administration, and then Steve Schwabel, who was, of course, on the court, president of the court, and some of you may not recall, was a former principal deputy legal advisor himself in the State Department. So that was the group that has nominated Joan. The ICJ statute also urges the national group to consult with the highest court of justice in the country and with other institutions knowledgeable about international law, which as soon as we had received Tom Bergenthal's resignation, Harold convened us, and we did so, asking, of course, preeminently the American Society of International Law, the American Bar Association, American branch of the International Law Association, and some other groups. And we did, of course, consult, as we have done in the past, the Chief Justice of the United States. The Chief Justice wrote back to us saying that if Joan is elected to the International Court of Justice, that he would start citing ICJ opinions in Supreme Court decisions. So we took that as a very important statement. I'm kidding. By tradition, the Chief Justice never writes back. But we did get a nice note from his administrative assistant. We did get important recommendations from the American Society of International Law and other groups. It was a very difficult decision because we had many qualified candidates, I think a number of whom could easily be on the court. In the end, though, after several rounds of discussion, 2 weeks ago on June 14th, the national group did unanimously agree that Joan Donahue was the most qualified candidate, and we are pleased to nominate her. Harold will go into some more of the reasons, but I just want to say a word about my personal experience with Joan, since I was responsible for bringing her back into government after a sojourn in the private sector. I first met Joan, amusingly, in 1999 when I was a lawyer at the Justice Department. Joan was then the Deputy General Counsel of the Treasury Department, where she had been recruited by then Deputy Secretary Stu Eisenstadt, to whose attention she had come at the State Department. She had had a stellar 15-year career in the legal advisor's office. The State Department at that point had been the assistant legal advisor in charge of 2 important offices, including the Economic and Trade Office. Stu Eisenstadt recruited her over to be the Deputy General Counsel at Treasury. And in fact, I had been talking to Joan about going to work for Joan. We, at the end, decided that I was not going to do that. I was going to stay at the Justice Department. But 9 years later, it was my great privilege to be able to recruit Joan back into the government. She, at that point, had moved back to the legal advisor's office briefly to be deputy legal advisor, then was the general counsel of Freddie Mac, the big mortgage company, moved on to teach international law at GW. Fred Lawrence is the dean of GW. We're delighted that you are here. We have given to GW many of our distinguished members, and now you will have another faculty member, we hope, on the court. I talked to Joan about coming back to the legal advisor's office. Initially, she wanted to wanted to come back to our L family. She wanted to work in the employment law area, in large part so that she could spend more time with her family, and did a terrific job on employment litigation issues. In 2007, though, I chose to reorganize the front office of the legal advisor's office when we had 2 departures. Sam Whitten, who many of you know, moved into a policy position, and Ron Bettauer retired. With a little bit of arm twisting, I persuaded Joan to move up to become the principal deputy in the legal advisor's office, so the senior career international lawyer at the State Department, and my alter ego. And the point is, for those of you, and almost everybody here has run something, to put this amount of confidence in someone is a significant task. I had brought Joan back into the government. I knew I was going to be leaving in 15 months. This is someone who the Secretary of State was going to have confidence in, that the entire 300-person office, the legal advisor's office, was going to have confidence in, and that who was going to, for some period of time, because it always happens this way, and it turned out to be a longer period of time in this case, would have to serve as the acting legal advisor after I stepped down. I spent a long time on this decision, but was convinced that Joan was the right candidate, and I was not disappointed. She is a top-flight international lawyer, broadly versed in all areas of international law, particularly economic and trade law, but also environmental law, diplomatic law, a whole variety of different issues. She is an international lawyer of the top caliber. In addition, though, for me in the legal advisor's office, and I think for a reason I'll explain this could become important, she is a top flight manager. She is a terrific manager of people, very efficient, very effective. That was going to be important for me in managing the legal advisor's office. The reason I say it's important is Joan, as you know, will be filling out the rest of Tom Bergenthal's term for 4 more years. Then we hope she will run for re-election. Joan has said she is interested in staying on. If Joan is re-elected, I am convinced that she would be a top leader in the International Court of Justice and would bring to the court the skills that she brought in the legal advisor's office. I had a wonderful time being the legal advisor. I think Harold is enjoying it as well. The issues are wonderful. L can be a difficult place to manage. There are rotations. There are people who want different jobs. Joan did a terrific job as the principal deputy. Secretary Rice had confidence in her. I had confidence in her. She dealt with the most difficult issues, including being the principal lawyer on the negotiation of the Iraq Status of Forces Agreement, part of which she did in discussions in Arabic. She speaks Arabic, which I think will bring a new dimension to the court. Joan was a fantastic principal deputy legal advisor for me. I knew when I stepped down as legal advisor that I was leading legal advisor's office in good shape, and I have the same degree of confidence that when Joan goes onto the court, that she will earn the same respect both on the court but in the broader international community that she had in the legal advisor's office. So I was extremely pleased to be able to support Harold, the other members of the national group, in nominating Joan Donahue.
I'm grateful to John Bellinger for many things, but none more than the appointment of Joan Donahue to be the principal deputy legal advisor at the State Department, who served as acting legal advisor while I was under confirmation and has served as my principal deputy for the last year. I met Joan Donahue in 1982. We were associates together at Covington and Burling. I was working for Peter Truboff because I was interested in international law. Joan was working on litigation matters. We became friends. We went on canoe trips together, and I never talked to her about international law at all. 28 years later, I returned to the State Department where she was the principal deputy, and at that point I had already heard of her extraordinary reputation. From 1998 to 2001, when I was in the Clinton administration, Joan had earned a reputation not just as a top-flight private attorney before she came to the State Department, but had served as the assistant legal advisor for African affairs, for oceans and environment, in diplomatic law and litigation, had worked on the Nicaragua case at the ICJ, had become the trusted legal advisor of Stu Eisenstadt, who was then Undersecretary for Economic and Business Affairs, and had just been made a deputy at the legal advisor's office. And I had some chance to work with her then, but that opportunity was multiplied 1,000-fold since I had a chance to return. When people ask you who is Joan Donahue, you could ask who is David Souter, who is Sandra Day O'Connor. They are people who are less well known at the time that they're appointed in some circles, extremely well known in others, and over time win the universal respect and admiration of everyone because of their extraordinary ability and their extraordinary human qualities. Joan is a little different. She's from California. Those in The Hague are going to have to adapt to that. She was educated at the University of California at Santa Cruz, where she was a child prodigy. She earned a double BA in Russian studies and biology. Not many people do that. And as John said, she has studied Arabic, Spanish, and is again refreshing her knowledge of French. and then studied international law at the University of California at Berkeley before coming here. She has been in the academic world. She's taught international law at Georgetown, George Washington, and at Berkeley. She's been an International Affairs Fellow at the Council of Foreign Relations. But she is quintessentially a government lawyer. And I say that in the finest tradition of the great government lawyers who have assumed judicial positions along the way, not just at the legal advisor's office, but at the Treasury, where she is Deputy General Counsel, and at Freddie Mac, where she is Associate General Counsel and Corporate Secretary. She has served under both Democratic and Republican administrations, and she has excelled under all of them. She has earned the Federal Bar Association's Younger Federal Lawyer Award, the Presidential Rank Award, the Distinguished Honor Award given by the Secretary of State, etc. I will say a couple things about Joan. I have worked with many, many international lawyers in my life, academics, private attorneys, NGO attorneys, intergovernmental attorneys, governmental lawyers. I have never worked with anyone more able, more knowledgeable, more fair than Joan Donahue. She is the most outstanding international lawyer I have had the privilege to work with in the government, period. And I think that she will be a judge on the International Court of Justice who will be of the rank and higher than those who have served for the U.S. government. I say that with utter certainty, that when the history of the U.S. representation on the International Court of Justice is written, Joan's name will be in the very top tier of those we have picked to serve in that judicial post. She is a very young person, one of her virtues, and we hope we'll have a chance to serve for a generation. And the measure of her accomplishment, as great as it is at this moment, will be when she has completed that service, which I think will serve to bring the U.S. much closer to the system of international law that has developed under the ICJ. A second point is that Joan exemplifies the values of the career legal service of the U.S. government and the career attorneys in the legal advisor's office. We have endured a very difficult period in the relationship between the United States and international law. There is no one who has done more to preserve the integrity of the U.S. relationship with international law, not me, not John, than Joan Donahue. And I think that that's a reason alone why she will be welcome to the court. And third, she's a person who's admired and respected and actually beloved by everyone she knows well. At the legal advisor's office, it's not easy to be beloved. But Joan Donahue is, and everyone who has worked with her will tell you that there's no one who is tougher, more fair, harder working, more capable of tackling a hard problem, more collegial, more calm under pressure, and I think most subtly able to see the relationship between law and international politics and complex issues that involve the most sensitive handling and understanding of the legal issues in question. This is a set of qualities that you can only earn through a lifelong of experience. Joan has it, and I am just very excited that I will have the opportunity to say that I worked with Judge Donoghue during my time in the U.S. government. And with that, I'd like to turn it over to the next U.S. judge on the International Court of Justice, Joan Donahue.
Well, thank you to all of you for being here, and thank you especially to the Society and to Betsy Anderson and the staff for putting on this event. I very much appreciate the opportunity to be here. I think I've been, obviously, an international lawyer for a long time, been to many events in Tiller House, always found them valuable, but it's quite thrilling to be here for this event, and I thank you very much. Please extend my thanks as well to David and to Lucy for their kind remarks. And I also owe a thanks to the national group two of whom are seated with me. Thank you to both of you, to your colleagues, for nominating me. It is a very unusual system, obviously, this national group nomination. You've done your part, and now I have to do my part with a little help from the U.S. mission in New York and get myself elected. But I'm not going to do that quite yet because many of you noticed I was on crutches and I've got a broken leg. So I've got to get that behind me, and then I'll be
So
going.
did Justice Sotomayor. We read this.
Yeah, there was a thought that maybe that worked for her. So that worked for me perhaps as well. I want to say a little bit about some thoughts about the court, but before I do that, I just also mention that my two sons are here, Adam and Casey, and thank you to both of you for coming as well. It's really nice to look around and see people I know from so many phases of my life. People from Covington here, and various people from L, some of whom I worked with long ago, some of whom I've worked with more recently. I very much appreciate you being here. The embassy representatives, people who serve on other international bodies like the International Law Commission, someone who was in L before I even joined L. It's just all of us who come together, professors, members of the society. We all come together from different perches to work on the same topic of international law that is our passion and our field. Thank you to all of you. So I am eager to get to the court, but first I have to get elected. And many people have said to me, well, you're from the U.S., you're a permanent member, you'll get elected, it won't be contested, what's the problem? And in all likelihood, they're right. But I feel that it is important for me to not take it for granted, to not only get the votes, but to earn them. And so as soon as I do get rid of this cast, I do plan to go up to New York and work with the mission and really try to be quite conscientious in meeting with as many missions as I can and trying to talk to them about my thoughts about the court and about international law and get their thoughts and hear what they have to say, because I'm not the U.S. judge. That's a shorthand that one hears, and I know Judge Brower is familiar with this as well. People use these shorthands of U.S. judge, but I'm not representing the government when I'm on the court. I will be elected, if I am, by the General Assembly and the Security Council, so I'll be representing all of them. So I feel that's quite important, and I do take that seriously. So I just thought I'd mention what I see as three trends in the court and why they make me especially excited about going to The Hague and why I think they make me a good fit for the position at this point. The first is the trend in the number of cases, and then second is the expansion of the kind of geographic scope of the court's remit, the kinds of cases that have been coming in from various parts of the world. And then the third is the breadth of the topics that the court has been facing most recently. I saw a statistic that I'll just mention on the numbers front because it's pretty interesting, I thought. The court had an average of 3 cases a year through the 1960s, about 5 cases a year through the 1980s, 13 through the 90s, and an average of 20 a year for the last decade. So pretty big trend, and if you plotted it, it's not a straight line, it's going up. And to me, that's very exciting. And I'd say it's not just because I like to work hard, and you heard a bit about that already, and I do. But it's exciting to be part of an institution that's dynamic, that's moving forward, and that's attracting interest as a forum for resolving disputes, for addressing issues. That means that there's a sense of energy there that I think is really fun to be a part of. The second reason it interests me, and this goes to John's point about management, is when you have that kind of a change in the docket, things have to change in the institution as well to deal with it in the same way that in the Office of Legal Advisor, certainly from the time I left in 2001 to the time I came back, the office grew a lot. And you have to change the way you run things. And the court has been grappling with that. For example, the recent addition of clerks is one development. And I look forward to working with the members of the court once I'm there and once I get my feet on the ground and learn about the place to help think about how I can contribute to managing the court, modernizing, and otherwise managing an institution that has a changed docket in terms of the size and the profile of the cases, et cetera. That seems like something that will be fun and something that my background will equip me to contribute on. And the second point on the geographic diversity of the cases, it's quite interesting to see. We do call the court the World Court, and it is World Court in the sense of principal organ of the UN, elected by the General Assembly and the Security Council. But at times, if one looked at the docket, it might seem, well, it's not really a World Court in terms of what cases are present. But if you look back over the recent docket, it's actually quite striking, and this is something that President Owada pointed out when he was up addressing the UN last fall in his remarks. The number of cases, if you kind of put up a map and put pins in it, you'd say, whoa, there are a lot of countries that are affected by these cases, maybe as parties or otherwise implicated by the cases that are pending. And I think that's quite exciting, but it's also important because it means that there will be more countries focused on the results of the cases. And I think that's significant in terms of the way one thinks about the legitimacy of the ICJ's jurisprudence. That's a topic that I think is an important one for everyone in the United States. And as has been mentioned, I really sort of cut my teeth as an international lawyer in the Nicaragua case. So I joined the Office of the Legal Advisor in April of 1984, and I was, having come from a litigation background at Covington, I was immediately assigned to write one of the jurisdictional arguments in the Nicaragua case. And while I was writing it, of course, there was a much bigger swirl going on about the case, which really, I think, provoked a lively discussion in the United States, both within the government and in academia, and among all of those interested in international law, about the role of the court, and obviously ultimately led to the United States withdrawal of its acceptance of compulsory jurisdiction. So you've got legitimacy questions that have arisen in the United States that have led to, I think, some good discussions, and some have remained steadfast in the view that the court is a terrific institution, and others have had reservations. But that's sort of percolating here, and that's an issue that I think would be quite interesting to engage in as a U.S. judge. I think it's quite important for the U.S. judge on the ICJ to be prepared to get out in the United States and talk about the court and hear people's reactions and concerns and address them, because the perspectives on the court in the United States can be quite different from the perspectives that one hears elsewhere. But at the same time, shifting away from the United States and back to the point about geographic diversity, what makes a decision look legitimate here might not be quite the same as what makes it look legitimate in another country. And I think it will be important for me on the court to be mindful of that, to be thinking about the fact that this is an institution, the output of which will be judged by diverse observers, not only in the United States, but also in foreign governments, and not only in governments, in other kinds of institutions, in NGOs, for example. So I think that the geographic diversity will also help shape the way that I need to be approaching the work of the court. Then the last point that I wanted to make about the current docket of the court is the breadth of the issues in terms of the topics that are covered. And this is really incredibly exciting to me, because the great thing about the job I have now is the diversity of the topics. And frankly, one of the things I like the most about it is that I never know what will walk in the door. It's quite often that I come into work on a Monday thinking that I'm going to be very immersed in topic A, and by the end of the week, I've never had time to look at topic A because topic B, which I didn't even know about, has blown up, and I've immersed myself in that the whole week. And in this case, in this job, others will be defining my inbox for me. I won't have any control over that, really. And I like that. I like the fact that pretty much any topic could walk in, and I feel equipped for that because I've done such a variety of things in international law. But the part about it that I like the most is the fact that inevitably the cases that come to the court will be difficult. No states are going to bother, or no UN organs are going to bother pushing a case forward to the World Court unless there's something very complex. The legal issues may be complex, the setting may be complex. If it's coming to the ICJ, it's challenging in some way or another. And that's appealing to me, and it also means that I will need to do something that I like a lot in my current job, which is to try to synthesize the various pieces of international law and put them together in a way that makes sense. But I'll also get to do something that I don't do in my current job, which is in the Office of the Legal Advisor, we give quite a bit of advice on very difficult issues that we share with our clients, but that isn't appropriate to make public. So quite a bit of what I've produced in terms of legal analysis would be invisible to you and to others. And on the International Court of Justice, I'll have an opportunity to write opinions and contribute to shaping the opinions of others in a way that will be visible and I hope will have an impact in shaping international law. And I hope will be durable, because I have found in my career in L that the more difficult the questions are, the more we find ourselves routing around in the dusty old PCIJ reports to look for sentences here or there that actually help us put stuff together. So that's part of what I'm excited about, and I think it is a consequence of the fact that the ICJ has this broad remit. The last aspect associated with the kinds of issues in the court that I think is worthy of mention is the two things that seem to be happening simultaneously that I think will be interesting to watch over the next decade or so. One, we now have a pretty large group of specialized courts and tribunals out there who are producing jurisprudence on issues that overlap in many respects with that of the ICJ, but that have a different mandate. So you have obviously the criminal tribunals, and the WTO has a very rich jurisprudence. You have the U.S.-Iran Tribunal, and all of these have a very specialized focus, and the parties that appear before them look different from the parties that appear before the United States in some cases. And some of them are state-to-state mechanisms, but others are different. You've got human rights mechanisms where the person who initiates is an individual. That jurisprudence is out there being developed, and in parallel with that, you've got the ICJ with a broader mandate, but also in its docket, one sees cases that are based on human rights instruments and human rights law. That's being developed, and it will be quite interesting to see how the ICJ sorts through those issues as they apply to the state-to-state relationship, at the same time that we have issues of accountability being addressed in the tribunals and matters of human rights obligations towards individuals being addressed in other bodies such as the European Court. So I'm looking forward to that, and also to the fact that some of the cases will be ones that involve issues that haven't crossed my path at all as a U.S. lawyer, because they involve maybe a treaty, a European treaty that the United States isn't a party to, or another regional treaty, or a bilateral treaty involving states that I'm totally unfamiliar with. And that sounds great to me. I think I'll be able to contribute drawing on my background with respect to related instruments and with international law generally, and I'm looking forward to that. So I will close just to say those are the sorts of things I have in mind when I look ahead to this exciting experience. I want to thank all of you again for joining us here. It's a real privilege to be with all of you here, and I look forward to serving if I'm elected. Thank you.
Well, thank you, Joan. You've given us lots to think about, and we will be very much looking forward to your reflections on the court come up, in the months and years to come. I welcome you all to stay and enjoy our hospitality, and I'm sure Joan will linger and answer questions and be eager for discussion. So please enjoy Tiller House.